What we're talking about when we talk about the Marchman Act is involuntary admission for a two-phase process. And that process includes assessment and stabilization and or treatment services. The good sign that that patient is appropriate for a Marchman Act is that they are in such a state of ignorance or denial of their disease. We're talking about a substance use disorder, that involuntary admission is the only hope for immediately getting them the care that they need. Here are the criteria, and this is what we would have to prove at the hearing for involuntary treatment services when we're seeking that up to 90-day order.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Craig Robinson. Craig Robinson is a partner at Robinson & Casey PLLC, a law firm devoted to helping families navigate the challenges of addiction and mental health by securing access to life-saving treatment for their loved ones. With licensure to practice in Pennsylvania, New Jersey, and Florida, as well as a federal admission to the U.S. District Courts for the Eastern District of Pennsylvania, the District of New Jersey, and the Southern District of Florida, Craig brings a wealth of legal experience to every case. The webinar that you're about to watch will be approximately 1 hour, and Craig will be taking questions from the audience at the end of the webinar, time permitting. So if you have any questions that you'd like to submit, please feel free to do so by clicking the Q&A button in the control panel at the bottom of your screen and submitting them there. Now, without further ado, here is Craig to discuss involuntary assessment and intervention, where the Marchman Act could change your practice.
Thank you so much, Nina. I appreciate that, and welcome to everybody. Okay, it's great to be with you all, and thank you for joining. Good afternoon or good morning, I guess, depending on where you are in the country. Again, my name is Craig Robinson, and just to give you a little bit of background on, I know that some of you may not be very familiar with what we're going to be talking about today, but essentially we're talking about a law called the Marchman Act, and I'm really going to kind of give an overview, and I'll talk a little bit more later in the presentation about some other states and how other states handle the involuntary treatment process for substance use disorders and co-occurring mental health disorders. Just by way of a little bit more brief background, I myself also am a master's level social worker. I've worked in addiction and mental health treatment and am in long-term recovery myself from addiction and mental health disorders. So this is a topic that's very important to me, and I appreciate your time in kind of, getting to know this law and how it might impact you and your practice and most importantly, your clients, because I think addiction and mental health is something that these days it's hard to find somebody that hasn't been impacted some way or another. I know that many of you might be practicing family law, probate, criminal defense law in other states other than Florida. So I think it's really important that you all know about this law. And that's really the goal of today. Some of the goals that I really want to accomplish today are to kind of give you all a legal framework of how this law works and how some other states handle the involuntary treatment process, kind of illustrate when the Marchman Act could be used, what particular scenarios it could be used. I'd also like to really accomplish kind of bridging the gap between behavioral health and law. I think we as attorneys have a really great opportunity to work with behavioral health professionals to try to find solutions for families who are looking to access treatment for addiction and mental health for a loved one and really feel like they've run out of options. I will cover a little bit about some practical, procedural, and ethical issues that come up in our practice. And I'd really like to kind of encourage you all to kind of be thinking about how it is that this law and other laws in other states might be able to impact your practice depending on what area you practice in. All right. So as I mentioned before, the Marchman Act really is, it is a Florida law. It's actually been around since 1993. It's codified in Florida law under Chapter 397. And it's gone through several revisions since 1993. Most recently, it went through a revision in July of 2024 really didn't change much substantively, more about procedural aspects of the process of the Marchman Act that were really predominantly changed in 2024. There's a few things that I'll cover in this presentation that also were changed. But essentially, the Marchman Act is what the law is known as. And what we're talking about when we talk about the Marchman Act is involuntary admission for a two-phase process. And that process includes assessment and stabilization and or treatment services. And so when we handle a Marchman Act case, and here at Robinson and Casey, all that we do is represent families or loved ones of an individual who has an issue with drugs or alcohol or a co-occurring mental health disorder. And we utilize the court system to essentially help them get their loved one to treatment. This is done in one of two ways. And this law is really intended for one of two kind of scenarios. The first scenario would be you have an individual who's suffering from a substance use disorder or co-occurring mental health disorder, and they absolutely will not enter the doors of an addiction treatment or dual licensed mental health facility. And so if they won't enter the doors of that facility and will never even admit to that facility, what we seek from the court initially is an order for involuntary admission for assessment and stabilization. So what we're asking the court to do in that particular scenario is to issue an order that would direct law enforcement to actually pick that individual up. I should mention this is a civil process. It is not a criminal process. The involvement of law enforcement is simply to ensure that the individual who is in harm's way, who has that substance use disorder or co-occurring mental health disorder, is able to be transported from either their home or wherever they're located directly to a facility for purposes of an involuntary admission. And so that's scenario one where we would use this law. The other scenario would be that someone is in an addiction treatment facility. They're in the state of Florida, and we know based on their history or based on maybe what they're telling the behavioral health professionals at that facility, that they are unlikely to follow through with clinical recommendations, meaning that they are intending to leave the facility against clinical advice, and that if they do so, that they would be in harm's way. I will get into the criteria in a later slide a little bit more, but essentially that's how it works in practice. Is either someone's in the facility and we want to keep them there and they're likely going to leave the facility, or they're not in the facility at all and we need to get them there via the assistance of law enforcement. I mentioned on this slide that that order for involuntary assessment and stabilization can be granted on an emergency basis. And it is a prerequisite to getting an order for involuntary treatment services. By emergency basis, generally when we file that initial petition, which we're requesting, generally we're requesting an ex parte order for involuntary assessment. When most of our families get to a point where they call us, they have tried everything else and the situation has become pretty dire. Generally, they are in crisis. Usually that timeline and the recent timeline consists of things like overdoses, criminal arrests, pretty erratic behavior. What we tend to see a lot now is folks that are in psychosis, unfortunately, that is oftentimes drug-induced psychosis. Most commonly would be cannabis-induced psychosis and amphetamine-induced psychosis. So if someone is taking Adderall or cocaine, and abusing that substance, oftentimes they can go into psychosis. And I should also mention cannabis is one that's the landscape of cannabis has changed significantly over the last few years. And especially with the THC concentration level in cannabis derived products has increased significantly, which that in combination with mental health disorders has caused a lot of psychosis. But generally, we're asking that court to grant that initial petition on an emergency basis. By emergency basis, generally, we're here in Palm Beach County. If we file a substantiated petition before noon on a weekday and the facts are there, then generally we'll have an order for involuntary admission same day. And we can usually have that individual picked up that same day that we file that petition and receive that order. Court's other option is they can also set that petition for a hearing to determine whether or not an involuntary admission is appropriate. I also mentioned on this slide that who can file a Marchman Act. So it can really be anyone with firsthand knowledge of the patient's behaviors that are associated with the need for the Marchman Act. Most commonly is obviously family. I mean, the most common case that we see are parents of adult children who are filing the petition. But oftentimes we'll have friends that want to step up to help a friend. Brothers and sisters, or, unfortunately we have adult children who are filing this to get one of their parents' assistance and treatment. But really, as we tell our families, really whoever knows the facts and who knows the most is usually the best petitioner. One other thing I wanted to note also for those folks that are out of state, the Marchman Act law, the only requirement essentially to file a Marchman Act is that the individual who needs treatment needs to be physically located in the state of Florida. So unlike other laws, for instance, guardianship, you can file that where the individual resides or where they're located. Here under the Marchman Act law, the only appropriate venue for filing a Marchman Act would be where the person is physically located. So as long as they are in the state of Florida, then we can file this Marchman Act, and we would file it in the county where they're located at the time that we file. Unfortunately, many individuals that have issues with addiction or transient are oftentimes moving from county to county, unfortunately. And so we really want to determine the location of the individual before we file and file it in that appropriate county. I also noted here too that county by county in Florida, there are a lot of procedural differences in the way counties will handle these cases. And so we work throughout the entire state of Florida. I think we've probably worked in most, if not all, counties in the state. And but it is different depending on which county you are in how that county might handle the case. When should a family use a Marchman Act? I think this is really important for especially folks, I think I highlighted this in the beginning, that are family law attorneys, estate planning attorneys, obviously criminal defense attorneys. Oftentimes our cases coincide with, criminal issues. And so usually there are oftentimes criminal defense attorneys that are involved in those cases. And we work with criminal defense attorneys and even family attorneys out of the state. Essentially what oftentimes they'll do is when they recommend to a family that they consult with a Marchman Act attorney, oftentimes there's a strategy that's developed to get an individual who's out of state into the state of Florida to essentially utilize the law to their advantage and hopefully save their life. And that's really what this is all about at the end of the day. But when should a family use the Marchman Act? Or really, this could apply to other involuntary processes as well. And we say here that really the good sign that patient is appropriate for a Marchman Act is that they are in such a state of ignorance or denial of their disease. We're talking about a substance use disorder, that involuntary admission is the only hope for immediately getting them the care that they need. I will also just clarify, when I say only hope, and I mentioned this at the onset of the presentation, most of our families are coming to us hopeless, right? They've tried everything else. Although we do have families that will call us and we always ask, have you asked your loved one if they will voluntarily admit the treatment? That's always preferred if that can happen. And sometimes we do have families that haven't even asked. So it's really important to know that the family has tried voluntary options. They try to get their loved one to admit to a facility on a voluntary basis. Usually when we have cases, there have been individuals that have admitted to multiple facilities. Usually they haven't completed a program as recommended by the facility by the time the family gets to us. I also mentioned that although the Marchman Act is not for everyone, addiction is life or death, and families really don't need to delay in getting help for their loved one. Statistics, I think from last year, these are approximate figures, are that there were about 50 million people in the United States who had a treatable substance use disorder. And only about 7% of those individuals actually received treatment for their substance use disorder. That leaves approximately 43 million people who have a substance use disorder in this country who are not getting the care that they need. in our experience, based on the calls that we get, it seems that a lot of those are families that would love for their loved one to admit to treatment, but that there's treatment resistance. So if that treatment resistance is there and that individual is in harm's way and the family considers it really to be life or death, that's when this Marchman Act would be appropriate. So just to kind of clarify here, the family would have to be aware of their loved one's use. Just a point to note on this, oftentimes families will know that the behaviors that the individual is exhibiting are such that they're acting in the manner that they typically act when they're using. Maybe they're slurring their speech. Maybe they are acting erratically. Maybe sometimes there's aggression. Sometimes there's violence, unfortunately, involved. But usually families know when a loved one who has a substance use disorder is under the influence. And so if they're aware of their loved one's use, or really I would add to that also that they're aware that their loved one's behaviors are such that they are acting in a fashion which would warrant the family to believe that they're under the influence or using. It has to have escalated into a substance use disorder or even an identifiable impairment. Chapter 397 of Florida law defines essentially substance abuse impaired as an individual having either a substance use disorder or a condition involving the use of a mood-altering substance in such a manner as to induce mental, emotional, or physical problems and cause socially dysfunctional behavior. So I know that's it's a word salad right there, but obviously what's really important is that individual has, there's reason to believe that they have that disorder and that they would be in harm's way. They have to have refused treatment. Also I put down there also that if the loved one is making threats of harm to themselves or others, that obviously is an appropriate time to maybe recommend a Marchman Act, although they don't have to be making threats of harm to themselves or others while actively suffering from a substance use disorder. Important to note that being in harm's way doesn't have to be necessarily direct. It can be an indirect result of behavior. So the intention might not be for the individual to harm themselves, such as suicidal ideation, but they might be acting in such a manner. Obviously, the most obvious ones would be driving under the influence. But other things too. We have individuals who are neglecting medical conditions. Oftentimes we'll have untreated conditions like diabetes or even some more serious conditions that are being left untreated as a result of someone's substance use disorder. Oftentimes that involves self-medication with a substance instead of taking the medication that's really appropriate for that condition. So how do you identify the right patient for the Marchman Act? I listed, obviously, in this, I know we're all attorneys here, so obviously some of these are really for clinicians oftentimes. I mean, when we train, I'll do trainings with clinicians, and but really the appropriate considerations remain the same for attorneys. I remember, just quick anecdotal story. I remember, I was a personal injury attorney for a number of years prior to shifting into this area. And I remember this is back in 2008 when I kind of started, that there were a number of my clients who were becoming addicted to substances that they were treating for an injury. Mostly, obviously opiate addiction was pretty prevalent at that point in time. And so even myself as a personal injury attorney remember thinking to myself, for some of my clients who were clearly addicted to these substances, is kind of thinking to myself, I wish that these individuals could get help. Obviously, at that point, I didn't know about the Marchman Act, but obviously, no matter what area of law that you're in, I think that these are things that, if you see them kind of running parallel, they're things to look for, and that might mean that it's a possible appropriate time to suggest to a family, certainly to suggest to your client, if it's your client that's the one with the substance use disorder, that, hey, maybe you want to get help. And I also should add, my contact information is in these slides. At any point after this, whether it's for a legal case or also if it's for just ideas about treatment and where someone should treat for an addiction or mental health disorder, certainly feel free to reach out to me about that. But Just some of those signs that a patient's appropriate for consideration of the Marchman Act. History of AMA, that stands for against medical advice. Sometimes we refer to it as ACA, against clinical advice. But that would be that someone has refused to accept medical advice or clinical advice at a prior facility. So usually if someone has left the facility, left facilities in the past, has never really completed treatment. And I also will just add, when I say treatment, I also mean throughout all levels of care of addiction treatment. Addiction treatment generally has multiple levels of care. There's detoxification, residential treatment, partial hospitalization, and then there's some lower levels of care, which typically is referred to as aftercare, intensive outpatient and outpatient therapy. Even if that individual is refusing to take those recommendations for aftercare recommendations, that would still qualify as an AMN, or refusing to accept medical advice. History of noncompliance with treatment. That could mean that they're not leaving the facility necessarily, but just that they're not taking the advice of their team, of their behavioral health team. That could be not taking their medications as prescribed, not going to group, not going to 12-step meetings if those are recommended, or not taking other advice that their clinical team is offering to them. Obviously, risk of harm to themselves or others if not in treatment. Kind of covered that a little bit already. But again, just to reiterate, that could be either direct or indirect risk of harm, that either they intend to harm themselves, or that they are not intending to, but they're acting in such a manner that they could be in harm's way. And I also will just add on that one, if there's a high risk of relapse, if someone is sober, but has a high risk of relapse if they were to not be in treatment. These days with fentanyl, just becoming such a huge issue in this country. Many illicit substances these days are cut with fentanyl, and even the smallest quantity of fentanyl could lead to an overdose. So if someone is using a drug that could be laced with fentanyl, that obviously puts them in harm's way in and of itself. The history or unlikelihood of completing aftercare, I touched upon that. High risk of relapse with consequences. Refusal to accept recommendations for sober living or structured living environment. This is one that we deal with pretty often, where an individual is recommended to live in a structured sober living home, otherwise sometimes referred to as a halfway house. And then that cycle kind of repeats itself, that individual is then falling back into the same patterns that they normally fall into. And then I also put going through the motions. Someone's in treatment, but they're really not invested in their own recovery, or they're going to AA meetings, but they're not getting a sponsor, and they're really, not actually following through with and really fully invested in their own recovery would be the best way that I can put it. So this is the legal criteria that I wanted to cover for the Marchman Act. Chapter 397 and the codification of the Marchman Act is a really a lengthy statute. So I really, for purposes of this presentation, have kind of tried to condense it down as much as possible. But essentially what we're looking at here on this slide is the criteria that we would have to prove to substantiate having someone under an involuntary treatment order. And so I should also I will just add, I had touched upon this in the beginning slides, but that first request that we're asking the court for is for that order for involuntary assessment. That's phase 1 of the Marchman Act process. What I'm referring to now is really phase 2 of the Marchman Act process, which is the involuntary treatment phase. The assessment phase is typically a 72-hour period. Individuals brought into a facility, they're required to remain at that facility for up to 72 hours so that they could be assessed to determine if they meet the criteria of the Marchman Act, which are these criteria. Or that individual is in treatment, but they're leaving that facility or likely not going to follow through with clinical recommendations. And so once we get that order for involuntary assessment, we would serve it on them at the facility. And then that facility would designate what's called a qualified professional. And that qualified professional is usually a therapist, although it can be a doctor or a nurse practitioner, but normally it's a licensed therapist in the state of Florida. And that therapist would be sitting down with that individual, collecting collateral information from the family or from us oftentimes. Usually we'll get it from the family and we'll send it over to that qualified professional so that they could take it into consideration when they're doing their assessment. And as long as the criteria are met at the end of that 72-hour assessment period, then we move to phase 2. And this is when we're asking the court, based on the results of that assessment, to issue a longer-term court order. By longer term under the Marchman Act, and I'll re-review this just in a slide or two as well, we're talking about court orders for a period of up to 90 days. 90 days is the ceiling under the Marchman Act statute. So it's the longest that one particular order for involuntary treatment services can be in place for. That 90 days is a maximum, not a minimum. And so essentially, once that order is in place, it would turn over the discretion to the facility where the individual was treating to determine length of time. So it could be less than 90 days. Essentially, if at any point that facility and the clinical team there determines that the person no longer meets criteria for the Marchman Act, they can be discharged at any time within that 90-day period. It also gives a discretion for that facility to determine level of care. By level of care, I just referred earlier to, detoxification, inpatient residential treatment, partial hospitalization, intensive outpatient, and even outpatient therapy. That facility or the clinician who's treating the individual would be in a place to essentially make recommendations, and then the individual under the order would be required to follow those recommendations. Nevertheless, here are the criteria, and this is what we would have to prove at the hearing for involuntary treatment services when we're seeking that up to 90-day order. And just note too, the petitioner has the burden of proving by clear and convincing evidence. So it's a high standard that we have to meet, a high burden of proof that we have to meet at that hearing. And we have to prove that, you look over to the left, that the respondent is substance abuse impaired. I defined that word, and I actually placed the definition for that term on the next slide as well. But essentially it means that the individual has a diagnosable substance use disorder. And that would be up to the clinician, obviously, to diagnose that disorder, the qualified professional performing the assessment. They have to have a history of lack of compliance with treatment for substance abuse. Just a quick anecdote on a couple of the cases that we've had here at our firm. One of the situations that we oftentimes, well, I shouldn't say oftentimes, but sometimes we'll run into here is we have a family who has a loved one. Let's just say it's parents of an adult child. And that adult child is in their 20s, let's say. And they have not been, the family has been trying to get them to go to treatment for their addiction for years, let's just say. And they have never admitted to a facility. But one of the challenges that we have faced is, how do you prove that someone has a history of lack of compliance with treatment for substance abuse if they've never actually been to a formal treatment center for substance abuse because they've essentially refused? The courts here, at least in Palm Beach County and Broward County, where the majority of Marchman Act cases are filed, have generally found that treatment for substance abuse also includes things like recommendations. Those recommendations can even be from a family doctor. We had a case at one point where a gentleman was admittedly drinking, I think, 18 to 20 drinks per day, somewhere in that neighborhood. But he had never been to treatment for substance abuse before. And the argument by his attorney at the case was that he doesn't have a lack of compliance with treatment for substance abuse because he's never, in fact, been to formal treatment for substance abuse. We actually argued in that case that he had been to his family doctor, and it was known to the family that the family doctor had recommended to him that he stop drinking. And he had not taken that recommendation. So we were able to argue that that actual recommendation and the failure to follow it was actually a lack of compliance with treatment for substance abuse. Successfully. And that, I think that makes sense, that recommendations from a doctor with regards to substance abuse can be treatment, in fact, for recommendations are a part of the treatment process. We also have to prove that because of such impairment, the respondent is unlikely to voluntarily participate in the recommended services or is unable to determine for himself or herself whether services are necessary. Pretty obvious. Are they likely or unlikely to really follow through with all the recommended services of that facility? Obviously, if they haven't even admitted to the facility, that one seems pretty obvious. So that they would be unlikely to participate in the recommended services or be able to determine for themselves whether services are necessary. And then there's and then for, one of my favorites in law, there's an and after that portion of the paragraph. And then numbers 1 and 2 have an or between them. So you could have one or the other. But without services, the respondent has to be likely to suffer from neglect or refusal to care for himself or herself, and that such neglect or refusal has to pose a real and present threat of substantial harm to his or her well-being, and that without services, the respondent would cause serious bodily harm to himself, herself, or another in the near future, as evidenced by recent behavior, or you can prove that the respondent's refusal to voluntarily receive care is based on judgment so impaired by reason of substance abuse that the respondent is incapable of appreciating his or her need for care and making a rational decision regarding that need for care. Just to clarify, essentially what that is saying is that the inability or the being incapable to appreciate that need for care has to be based on the substance abuse. So it can't be based on some other factor like a mental health condition. There does have to be a basis for this that's founded in the substance abuse that's causing that individual to not be able to appreciate their need for care. Those are the criteria that we would have to prove at the involuntary treatment phase. I put some key definitions here in this slide. I think I've said this now a few times, but that substance abuse impaired definition, where you see sections that are underlined, those are parts of the definition under Chapter 397 that were added in July of 2024 during the most recent revision of the law. So we've added now that it can mean having a substance use disorder. And that's really for the clinicians that are performing these assessments. It gives them the ability to use the DSM-5, which is a diagnostic tool. So they can use the criteria in that DSM that they're used to using when they are determining whether or not someone meets that definition of substance abuse impaired. I put the definition of involuntary services. And the reason I did that is just to kind of reiterate that this does mean the array of behavioral health services. And really kind of what that, I think an important point is that can also include outpatient services. We have cases where the licensed service provider, the entity essentially that is making clinical recommendations, is an outpatient therapist. It's not a facility. So someone may still be under a court order. They may be seeing a therapist on an outpatient basis, but it puts an extra security blanket in place to make sure that that individual stays on the right path and continues to follow clinical recommendations of that outpatient therapist. I also put the definition of substance abuse. I find this to be interesting out of Chapter 397. But it means the misuse or abuse of or dependence on alcohol, illicit drugs, or prescription medications. Now, if you read this literally, which I have many times, and I've always kind of fascinated that really, if you read this literally, it would mean that if you're dependent upon a prescription medication, that would mean that you qualify for substance abuse. So theoretically, if someone is dependent upon their blood pressure medication, that would really meet this definition from a literal standpoint, but that's obviously not what was intended. We're talking about prescription medications, which generally are mood altering. But nevertheless, the dependence upon or dependence on piece has been important for us because medical marijuana is legal here in Florida. And so oftentimes we'll face the argument that, well, I can't be abusing my marijuana because I have a prescription for it. And so even if an individual has become dependent upon that, because there really are no limits when someone is given a prescription for a medical marijuana card here as to how much, well, there are limits, but they're pretty high, meaning that they could purchase a lot of marijuana with that medical marijuana card, more than really one individual would need. But nevertheless, that can qualify if they are dependent upon that substance. Even if it is prescribed, it can still meet the definition of substance abuse. So I'll just touch upon how we work together with behavioral health professionals. I don't know if anybody listening to this is in the mental health field. I hope that there are some. But really, it's all about communication for us. We work with a lot of behavioral health professionals. And what I'm talking about really are most common ones we work with are therapists that are in treatment facilities, but we're also working with admissions staff that work for addiction treatment facilities. We're also working with interventionists, individuals that are intervening upon behavioral health professionals that are intervening upon an individual with a substance use disorder, and what are called case managers. Case managers are those that would be kind of coordinating treatment on behalf of a family or an individual, and also treatment placement specialists, individuals who are trying to identify the most appropriate treatment arrangements for somebody. But we really work with them. I put in this slide that the family and the facility, or really the family and the behavioral health professional, really have to be aligned before the attorney would file this petition. And we really have to communicate. For instance, if we have a facility where an individual is going to be going, those arrangements really have to be made with the facility in advance. The last thing a behavioral health addiction treatment facility wants to have happen is someone show up in via law enforcement without them having any ability to prepare. Have a bed available, obviously, is important, but also just have kind of some of the background as to what's led the family to this point to take this step. And so we're really very communicative with the behavioral health professionals that are working those cases with us. And also, law enforcement oftentimes doesn't give a lot of advance warning, for this. And so they will go out and pick an individual up rather quickly oftentimes. And so it's important that we kind of have our ducks in a row before we file this into the facility, and all behavioral health professionals that are involved in the process are kind of aware and updated on what's going on. I put a section in this about a pre-admission assessment. It's important, I think, for attorneys to know this as well. Many of these facilities, addiction treatment facilities, they require a pre-admission assessment, meaning they require or have a procedure that they need to talk to the patient before the patient's admission to the facility. And obviously, as we tell them, most of the time that's not really possible, because if an individual is coming there involuntarily, they're likely not going to get on the phone with the facility and have a conversation. They're often pretty resistant at that point in time. And so usually with the facilities that we work with, the family speaking to the facility in advance will suffice in that circumstance. And this just kind of covers that a little bit more too. And I want to make sure that we're okay on time, because I know I'm running a little bit short. So essentially this, is the best way that we can work with those facilities and those behavioral health professionals is to make sure that they have all the information that they would need in advance. The whole story, what's led the family to this point, what is the individual using, how much are they using, how often are they using it, what behaviors are they exhibiting as a result of their use. And then also I just put too that oftentimes in Florida, this depends on county by county, but obviously there are confidentiality laws that apply. But under 42 CFR Part 2, there are good cause exceptions. Sometimes what the involuntary admission, whether it be the assessment order or the treatment services order, the judge will oftentimes put language in that order that there is a good cause exception for federal confidentiality laws, usually for a limited purpose, really just to kind of offer the results of the assessment so those can be shared with the attorneys that are involved in the case. Presence in treatment, diagnosis, prognosis, and any recommendations that the facility is making. Those are kind of the touch points that are generally encapsulated by any good cause exception. It doesn't open the family up to a full release from the facility, or the attorneys up to a full release from the facility, meaning I may not be able to get the full patient's records. And quite honestly, I don't want or need those records. Really what I need is the information that's important to know whether or not those criteria are met, and whether or not an involuntary treatment order would be appropriate. Okay, just some key points about the Marchman Act, and I know that I touched upon some of these already, but that assessment and stabilization period that I mentioned before is a 72-hour period. That 72-hour period begins either if the person's being brought via law enforcement. It would begin once the person arrives at the facility, or if the person is already in the facility and that order is being served on them at the facility, then it would begin the moment they're served. And the facility may hold the respondent beyond the 72-hour assessment period. I'll get into the reasons why they might be able to hold the respondent beyond the 72-hour period in the next slide. And if they are able to hold the patient or retain the patient until beyond the 72-hour period, that would be until the hearing on involuntary treatment services. So until that hearing where we're seeking that up to 90-day order. And that hearing is required by statute to be set within 10 working days of the initial filing. So the initial filing is a petition which requests both an involuntary treatment order and a request for an involuntary assessment order. So from the filing of that petition until the hearing has to be within 10 working days. Under treatment services, I mentioned that it's an up to 90-day order to receive treatment services at a designated facility. Should also really change that to licensed service provider. Doesn't necessarily have to be a facility. It can be on an outpatient basis. We've had outpatient psychiatrists that have served as the licensed service provider. And as I mentioned, we've also had outpatient therapists that have served as the licensed service provider. The treatment facility determines both the level of care and the length of stay. Extensions of the 90-day order. Just a quick anecdote. 90 days in treatment for an individual that is treatment resistant is not always a sufficient time for an individual to be in treatment to really get the help that they need. One other quick note that I'll add, we recently had a gentleman in our office that we actually Marchman Acted. We represented his mother, and he had reached out to us a few years after we had Marchman Acted him. He's been sober and he's been living a good life, since. But I had the opportunity to talk to him. I was asking him about kind of the psychology that he was going through while he was under the Marchman Act, because he was extended a couple of times. I think he ended up being in treatment or under the Marchman Act for about 7 or 8 months in total. And he was telling me that for that first 90 days, he was kind of counting down the clock, so to speak. And then he got extended. And once he got extended, he said in his mind, there was a shift at that point in time, that he began to realize that I'm really not going to get out of this court order until I am invested in my own recovery. And he said at that point in time, the way he described it is that he really began to kind of want it, meaning want his own recovery, wanted to be sober. And sometimes it can take that long for an individual to develop that willingness. And so I will just say extensions are possible for additional periods of up to 90 days. More than one can be sought. Our most common case will usually involve an extension, maybe not for a full 90 days, but it might just be there to cover intensive outpatient and outpatient therapy, because that tends to be a time period where many individuals with substance use disorders kind of fall off the pathway of recovery. But usually that one extension is more than average of what we kind of have in our cases. Failure to comply. So I did want to touch upon this. The leverage of the Marchman Act. I mentioned it's a civil law. It's not a criminal law. So there is no criminal enforcement of this. And I'm glad there's not. I'm glad that it is a civil law. Essentially, our leverage of the Marchman Act is the civil contempt process. So, obviously, main difference, at least in Florida, between civil and criminal contempt is the intent, right? The intent of this is to force compliance with a court order. It is not to punish the individual. And so I mentioned here that the options are treatment, jail, or other consequences, such as restarting the 90-day order. We have not had many individuals go to jail under a Marchman Act, in about maybe 20 or so, I would say. And those are individuals that left the treatment facility while under a court order and refused to go back. Normally, the contempt process and just initiating the contempt process and filing a motion to show cause for contempt and enforcement, usually the filing of that motion and it being set for a hearing and us notifying the respondent is usually sufficient to encourage that individual to return to treatment. We really never want to see somebody go to jail under a Marchman Act. That is not the goal of this law. But I will say that the times that it has happened, it can be an effective intervention. Someone unfortunately goes to jail under a Marchman Act because, they have the opportunity usually pretty quickly to purge the contempt and return to treatment. So usually they'll be brought back before the judge or the magistrate within a few days or a week, directly from jail, and they'll be given the keys to the jail cell, the opportunity to be to let out if they agree to go back to treatment. But there could be other consequences imposed, such as restarting the 90-day order. Someone's been in treatment for 45 days. Let's just say maybe they haven't left the facility, but they're non-compliant because they're not following the recommendations of the facility and the clinicians there. We have people that are oftentimes not going to group, they're not meeting with their therapist. And so we can use the contempt process from the legal perspective to encourage compliance, to encourage better behavior while the individual's in the facility. And so another consequence sometimes the court will impose is that, let's just say 45 days have gone by, the individual's not meeting with their therapist, they're not going to group therapy, they're not taking their medications as prescribed. The judge or the magistrate can restart that 90-day order, under the contempt process as well. I mentioned before that the individual under the assessment phase of the case can be held for a period of 72 hours of observation. It is up to 72 hours. And if there are certain criteria met, then they can be held beyond that 72 hours. This is the language directly out of the statute, but so the service provider may not hold the respondent for longer than 72 hours of observation unless, number one, the service provider seeks additional time and the court, after hearing, grants the motion. As I always tell our behavioral health professionals when I'm advising them on this, ignore that just because at least in our world, there is no way that we will get that hearing, to actually have a hearing and a motion be granted within 72 hours. It just doesn't happen in the procedures of those cases. So number two is kind of more important, that the respondent has to show signs of withdrawal or the need to be either detoxified or treated for a medical condition. And that would extend the amount of time the respondent may be held for observation until the issue is resolved, but no later than the scheduled hearing date, absent a court-approved extension. And then I also note in number three that if that 72-hour period ends on a weekend or a holiday, obviously the facility would get until the following working day to perform their assessment. I also will just note too that in number two, that note of either being detoxified or treated for a medical condition. Unfortunately, the law does not define the word medical condition. We've had a lot of conversation about that here in Florida about what is a medical condition. Is a substance use disorder or a mental health disorder a medical condition? And as I always tell the clinicians that we train, I don't know, because there is, unfortunately, it's one of those terms that's not defined by law. So I really have to defer to the experts on that, who are actually performing the assessment. If you feel that a substance use disorder or mental health disorder is a medical condition that puts the person in harm's way, then, the amount of time for that observation and assessment can be extended. Okay. Transmission of the assessment. This is also, it's important for attorneys if you're thinking about getting into this area, just to know that that assessment that's done within 72 hours, there's a report that is generated out of that assessment. That report does not have to be submitted within that 72-hour period. It can be submitted essentially no later than the close of business on the day before the hearing. So again, that hearing is set 10 working days out or within 10 working days, as long as it is submitted to the court on the day before the hearing by the close of business, then it is submitted timely. As I always tell our facilities that we work with, we prefer to have it a little bit more in advance. I don't like to get a assessment the night before the hearing and have to review it and figure out what it says and prepare for that hearing. But also the assessment must contain the recommendation on the level of substance abuse treatment required, relevant information on which the qualified professional's findings are based, any co-occurring mental health or other treatment needs. And I also just note that the qualified professional's failure to include a treatment recommendation, much like a recommendation of no treatment, shall result in the petition's dismissal. So as I always tell our facilities and qualified professionals, you have to have a treatment recommendation in that assessment. Just some other final points to be aware of. Assessment phase, qualified professional obligations of the licensed service provider. I mentioned this before. A qualified professional could be a doctor, nurse practitioner, or a licensed therapist. Here in Florida, we have generally it's an LCSW, a licensed clinical social worker, or an LMHC, a licensed mental health counselor, or a CAP or an MCAP, which is a certified addictions professional with a special certification, or an MCAT is a master's level certified addiction professional. Any of those initials after someone's name would mean that they are deemed to be a qualified professional for purposes of the Marchman Act. I put extensions in here. There's, if anyone's familiar with the statute, there used to be a 10-day filing requirement, which meant that if there was a 90-day order, that any extension would have to be filed within 10 days of the expiration of the order. So by day 80, that would have to be filed. That was removed in July of 2024. And so now an extension can be filed all the way up until day 90, until that order actually expires. Tricky part of that is that there has to be a hearing on that extension phase. And so if you wait till you file it on day 90, and you're going to have to wait for the court to set it for a hearing. And then technically between day 90 and whenever that hearing might be, there's no court order essentially in place holding that person in treatment. Treatment services order and confidentiality. I also touched upon this a little bit. We always run into this issue of whether or not the facility can report certain things to us as attorneys. And as we generally tell those facilities, we're kind of on a need to know basis. We really only need to know the things that we need to know. And the most important part of that is noncompliance. And the courts really always put language in the treatment services order that specifically states and authorizes the facility to communicate noncompliance, at the very least to the court. They may not be able to send information directly to us, the attorneys involved, but they can send it to the court and then we'll get copied on that correspondence to know if there's a problem with compliance at the facility. So I put this chart up here. I know that there's folks in other states. And I will just say that unfortunately, I say unfortunately because I believe that this law, the Marchman Act, has saved a lot of lives. At least in my experience, we have a lot of families who have kind of come back to us after the process is over. And even the respondents who have said that that this law was life-saving in their eyes. But this is kind of an overview of other states. I know that in California, for the folks in California, you all have something called a 5150, which is really a 72-hour hold that can include, reasons being can include mental health or alcoholism. But I will say in my experience, I'm talking to a lot of behavioral health professionals in California, that a 5150 works similarly to our Baker Act. We have a law here in Florida called the Baker Act, which I think mirrors in a lot of ways the 5150, which is really written and intended to be a short-term involuntary psychiatric stabilization. Those laws do include the ability to extend treatment. In Florida, we have something called assisted outpatient treatment that's written into the Baker Act statute. But in my experience, it's rarely utilized. And that's because it is really up to the hospital to determine that that's necessary. What tends to happen oftentimes is someone's, let's just say 5150 in California, they're brought into the hospital, they're unstable, they're going through a mental health crisis. Once they get to the hospital, they're administered medication, maybe an antipsychotic medication. They stabilize, once that medication is administered. And once the hospital determines that they are stable, that they no longer meet the criteria of the 5150 or the Baker Act, they can be discharged from the hospital. And so, and really by law, they should be. And so those laws typically don't provide the kind of a long-term solution that the Marchman Act really provides. And so from that standpoint, I think that this is really what separates the Marchman Act from those laws, is that it's intended to be a longer-term option. It's intended to provide real treatment, not just stabilization. And it also takes place in a non-lockdown facility. I should mention in Florida, and I don't know if I mentioned this yet, but there are 1,200 or so addiction treatment facilities, licensed addiction treatment facilities. And so when you look at a state like Kentucky, for instance, it has a law called Casey's Law, which actually in a lot of ways, when you read that statute, does look like the Marchman Act law. The difference being that in Kentucky, there really aren't the amount of quality addiction treatment facilities that there are in Florida. So I will say that it's really important for the family to select the right treatment center. And unfortunately, in other states, those options aren't really as significant as the amount of facilities that we have in Florida that are really doing extremely quality work. But I will also just note Pennsylvania, for those of you from Pennsylvania, there is a law that is currently in the Senate. It was just recently referred to Health and Human Services. I am told that it has a chance of getting passed. It's been proposed before. It's truly a bipartisan bill. It's proposed by two state senators. One's a Democrat, one's a Republican, and I really hope that it does. I've kind of been in touch with the folks up there as I'm licensed up there, and I'm hoping that it does pass, because I do believe that it will provide a lot of hope for a lot of families. But nevertheless, this is hopefully this information was given in your materials. But the bottom line really is that, unfortunately, there are no real other states that have anything in combination with the quality treatment facilities that we have here in the state of Florida. But I hope that changes. I will just note some noteworthy studies and cases. There's a case that recently came out called Burley versus the Village South in Florida. It's a 2025 case for those that are interested. I put the site there. But I will just say this is actually an interesting case. It was a wrongful death case. It utilized the Marchman Act statute as a basis, essentially, for liability in a wrongful death scenario, because the facility involved did not follow the procedures for administrative discharge of a patient while under a Marchman Act involuntary order. The patient, unfortunately, I think 48 days later, passed away of an overdose. When a facility is under a Marchman Act, when an individual is under a Marchman Act at a facility, that facility has some responsibilities, obviously, to that individual, especially when they find that they can no longer treat that individual sufficiently. They have to make sure that they make an appropriate referral and make arrangements to refer that individual to another facility. In this particular case, that didn't happen, and that was the basis for the wrongful death statute. But most importantly is, I think that it found that the Marchman Act was a basis, that it did instill a duty in the facility to make sure that appropriate arrangements were made for that referral. And so I think that's important, because here in Florida, I will tell you, I'm still surprised and shocked by how many clinicians, behavioral health professionals, don't really know either about the Marchman Act or really how it works in practice. And I really think, I look at it as kind of a responsibility for therapists and medical providers to really know about it, how it works, and just generally have an overview of how it functions and when it should be utilized. I think that's important. I also put a study from 2019 from the Journal of Addiction Nursing. And this is a study, actually, that one of the common things that we hear here at Robinson and Casey is that involuntary treatment doesn't work. The individual has to want the help in order for it to be effective. And these days, I think if you research enough and you have a position on something, you can likely find a study to substantiate your opinion. So there are a number of studies out there, I will just say, full disclosure. But this is one actually that really did a study of 120 veterans, 60 who were in treatment voluntarily and another 60 who were there involuntarily for alcohol use disorder. It was done through the VA, and really essentially it tracked those individuals and what we call the stages of change or stages of motivation, the motivation for treatment. And what it found, essentially, the overall conclusion of the study was that really there was no difference in the efficacy of involuntary treatment versus voluntary treatment. And I think this goes back to, if you really read the study, which I find to be very interesting, it really goes back to what I talked about before about that individual who was in our office, who really told me that, that willingness wasn't there at first. And it wasn't even there in the first 90-day period, but that willingness actually was developed over time. And that at some point it really it kicked in that this individual really wanted his own recovery. And that's really what this is all about, is to hopefully give people a chance at recovery. And I think it's a great thing that we have this law. If anyone has any questions for me, I know that we're just at about time. This is my contact information. I'll put up one more time so you all have it. Feel free to reach out to me. Email is probably the best way to reach me, but it's really great spending some time with all of you. I hope this was that you learned something out of this. That was my ultimate goal. So, Nina, thank you.
Wonderful. Thank you, Craig, so much for all of your insights. If you do have time to take a couple questions, that'd be wonderful. If not, that's
Of
okay.
course. Of course.
Wonderful. Awesome. Well, if you do have questions, then please feel free to submit them via the Q&A button in the control panel at the bottom of your screen for our audience members. All right. It looks like we've got a couple questions. So our first one is, what evidentiary showings tend to persuade courts most effectively when proving impairment?
Yeah, it's a great question. Most of our cases involve really testimony from family. That's really, sometimes we'll have scenarios where there is some documentary evidence, but really not often. Oftentimes, that even if there are medical records, we may not have them in time. There's really not enough time to subpoena those records oftentimes in these cases. So what we really rely upon most of the time is testimony, real credible testimony from family. That tends to be really the evidence that is provided in these hearings. And I will just say that the real kind of sticking point that we have oftentimes, and probably in most cases, is once somebody gets into this scenario where they're facing this up to 90-day order, oftentimes at that point they become violent. They say, I'm going to do it. I'm going to do it this time. But we've seen some situations where family members have kind of let it go at that point in time, and then unfortunately the worst happens. But most of it is credible testimony.
That makes sense. Thanks for that insight, Craig. Our next question is, how can attorneys ethically navigate situations where family members petition for Marchman Act intervention, but the client is resisting treatment and asserting their autonomy?
Yeah, another great question. Remember also that we represent the family. In our firm, we represent the family only, but you may have a client out there, that really needs the help. And so you might be in a position where you could recommend, to the family that they consider this, depending on the circumstances and depending on the ethical rules, obviously, of your state. It does vary by state, but essentially oftentimes what we'll have is individuals who are able ethically to communicate with family. And really all they do is kind of point them in our direction or another attorney who does the Marchman Act to at least consider it. And that's the end of the scenario at that point in time. And then we take on representation of the family and go from there.
Thank you, Craig. Our next question is, are there emerging best practices for coordinating with law enforcement when officers express reluctance to enforce treatment orders, especially when you're in a potentially resource-constrained county?
Yeah, there are. I would say that it's a great question as well. I'd say the best practice is we normally will, for pickups, we will have a private investigator who is former law enforcement. We have a few investigators with a team that we work with here in Florida that, one was a former narcotics detective for 25 years in Broward County, Florida. Another one was a homicide detective. And so we work with private investigators that can be at the scene for these pickups. So just to make sure that everything is kind of going smoothly, also that the officers are aware of where that individual is supposed to be taken to, but also really just in case, I will say it's surprising that a lot of law enforcement aren't, fully aware of the laws and how it functions and how it works. They've obviously heard of it to some degree, but I've been doing a lot of trainings actually with law enforcement to try to get them up to speed to make sure that they know their responsibilities and duties under the Marchman Act.
Thank you, Craig. Our last question for today, and again, thank you for your extra time, is, in contested hearings, how can lawyers most effectively present clinical evidence of incapacity when there's often not those longitudinal treatment records to lean on?
Yeah. So that's another great question. Could you actually put that question up one more time? I'm sorry. I guess it's under answered. I'm sorry. Okay.
Fine.
Yeah, how can lawyers most effectively present or challenge clinical evidence of incapacity? So just to be clear, We also aren't really necessarily talking about incapacity as in the term that's associated with guardianship, right? We're not, all that we're saying really is that they're incapable of appreciating their need for care and making a rational decision with regards to that. Without the longitudinal treatment records, it can become challenging to present that evidence because really the qualified professional who hasn't spent a lot of time with that individual. Now, they've also received a lot of information from the family. And what tends to happen in these cases is somebody finally gets the treatment and they might deny that they have a problem, right? They might say, everything's fine. My family's overreacting. They do drug tests at that point in time too, to determine what substances that individual tests positive for. So if there's a discrepancy there where the individual says, I don't know what they're talking about, I've never used cocaine, and they test positive for cocaine, that dishonesty tends to unfortunately kind of go hand in hand, with an individual who has a substance use disorder. And so that's pretty common. And so we really rely upon the qualified professional to use their best clinical judgment. And the courts really weigh that pretty heavily, on what that qualified professional says, what their opinion is. And a lot of that, unfortunately, deals with collateral information, the information provided by the family and the attorneys, which that qualified professional can find to be credible or not credible. I mean, they really have to weigh that. And we do a lot of training with those qualified professionals because this is not something they learn in school, I will tell you. Having gone through a master's program of social work, they did not really cover and prepare me to be able to testify potentially as an expert in court. And so we really rely upon them to give us their best sense of the potential harm if that individual were to not be in treatment involuntarily.
Thank you so much, Craig, for all of your insight and your presentation today. We've really enjoyed having you. We're so grateful that you were able to present with us today. And thank you to all of our audience members for submitting your questions and participating. We always love having you here. We want to thank you all so much for joining us for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to CLE credit opportunities through select live and on-demand webinars just like this one, so you can stay informed and meet your requirements. You will also enjoy an enhanced directory profile, AI-powered Justia chat to boost your leads, and exclusive discounts on Justia marketing solutions. To take advantage of these benefits and upgrade today, or just learn more, you can go to pro.justia.com. Thank you all so much for your time and have a wonderful rest of your day. Thank you. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.